An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
Ex Parte Merryman, 1861. Following the contentious election of 1860, Republican Abraham Lincoln was elected to the presidency without receiving a single electoral vote from a southern state. After his election, but before he took office, 7 southern states seceded from the Union: South Carolina, Mississippi, Florida, Alabama, Georgia, Louisiana, and Texas. On March 4th, Chief Justice Taney issued the oath of office to Lincoln. During his inaugural address, Lincoln attempted to alleviate the fears of the remaining slave states, which had not seceded, as to his intentions concerning slavery. Despite Lincoln's assurances, on April 12, 1861, Fort Sumter in South Carolina was fired upon by Confederate forces. Unable to receive federal reinforcements, it was surrendered 3 days later. Soon, the slave states of Virginia, North Carolina, Tennessee, and Arkansas joined the Confederacy. Though it is called the Civil War, Congress never formally voted on a declaration of war. Rather, President Lincoln prosecuted the military campaign through broad and largely unprecedented assertions of executive power. Ex Parte Merryman, 1861, considered whether the president could deny prisoners the right to ask a judge to determine the legality of their confinement. In the Anglo-American tradition, prisoners can petition a judge for what is known as a writ of habeas corpus. Habeas corpus is part of a Latin phrase meaning produce the body. This writ refers to a judicial order to a jailer to produce the prisoner's body to the court. Our Constitution follows this tradition. Article 1, Section 9, known as the Suspension Clause, provides, quote, "The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it." This clause does not specify whether the writ may be suspended by the President, by Congress, or by both, acting in concert. However, the provision appears in Article 1, which concerns the legislature's authority. It does not appear in Article 2, which concerns the President's authority. Often courts rely on a textualist argument, where the express text of the Constitution supports a certain result. However, here we're dealing with a structural argument. That is, the structure of the Constitution supports a different result. Even though the text of the Constitution is silent about which branch can suspend the writ, as a structural matter, because the power appears in Article 1 rather than in Article 2, that power should belong to Congress and not the presidency. Despite this structural argument, after hostilities began, President Lincoln unilaterally suspended the writ of habeas corpus and imposed martial law within some areas that had not seceded from the Union, including the slave state of Maryland. At the time, Congress was not in session. Study guide. Did President Lincoln have the unilateral power to suspend the writ? Does it matter that Congress was not in session at the time and was therefore unable to act? In Ex Parte Merryman, Chief Justice Roger Brooke Taney sharply criticized Lincoln's suspension of the writ as unconstitutional. The facts of this case are quite unusual. On May 25, 1861, John Merryman, a citizen of Maryland, was arrested by military force and detained at Fort McHenry in Baltimore. On May 26th, Chief Justice Taney issued a writ of habeas corpus directing General George Cadwalader to produce Merryman's body. Note that Taney did not order that Merryman must be released, only that he should be brought to the court for a hearing. General Cadwalader declined to produce Merryman, instead sending the Chief Justice a letter explaining his rationale. When informed that the general had not delivered Merryman's body, the Chief Justice issued an order holding the general in contempt. Taney subsequently issued a written opinion. Study guide. Notice that this opinion is rendered by Taney, who was serving at the Circuit Court District of Maryland, and not the Supreme Court. In what capacity did Taney even render this decision? Relying on the structural argument, Chief Justice Taney concluded that the President could not suspend the writ of habeas corpus. Only Congress had that power. Quote, I can see no ground whatever for supposing that the President, in any emergency or in any state of things, can authorize the suspension of the privileges of the writ of habeas corpus or the arrest of a citizen except in aid of the judicial power. He certainly does not faithfully execute the laws if he takes upon himself legislative power by suspending the writ of habeas corpus, and the judicial power also by arresting and imprisoning a person without due process of law. Afterwards, in an unusual move, Taney ordered that his written opinion should be laid before the President in order that he might perform his constitutional duty to enforce the laws by securing the obedience to the process of the United States. Although it is commonly argued that President Lincoln invoked his executive power to defy Taney's order, this claim has been challenged as among several myths surrounding the facts of Merryman. According to Professor Seth Barrett Tillman, Taney merely has opinion on the constitutionality of Lincoln's actions transmitted to the President. Quote, Taney issued no order to release Merryman. It follows, therefore, that Lincoln could not have ignored or defied it, nor could anyone else for that matter. Following Taney's decision, Merryman remained detained at Fort McHenry until he was transferred to the federal civilian authorities. He was indicted for treason and shortly thereafter was released on bail. 6 years later, in 1867, all charges against Merryman were dropped. Though the President never formally acknowledged Taney's opinion, Lincoln defended his decision to suspend the writ of habeas corpus in his July 4th message to a special session of Congress. Subsequently, Congress formally enacted a statute approving, legalizing, and making valid all the acts, proclamations, and orders of the President, etc., as if they had been issued and done under the previous express authority and direction of the Congress of the United States. Study Guide. Is this act of Congress relevant to an assessment of Lincoln's previous actions? Taney died in office 3 years later, in 1864, and Lincoln fittingly replaced the author of Dred Scott with anti-slavery lawyer Salmon P. Chase.